Item number 2, same, Milord, same.
Yeah, 2 onwards. I think there are several. 1 and 2. Right.
3.
May I please your lordship, my lord? This review application is covered by another review application.
There is a delay for 2 years.
Oh, I see.
The master, the present petitioner is retired as a headmaster. He is not getting the differential arrears salary, my lord. And as per the Honorable Apex Court, this review application was allowed on the judgment of this Honorable Apex Court, my lord.
No, it's okay. Tell us what the judgment is.
And it was
It's mentioned in this order.
my
Correct?
lord, my lord,
This is A. Francis.
my lord, my lord.
Ah,
And direct the opposite party to consider the application of the petitioner, my lord, in that the review application. If your lordship directed to the opposite party to consider if I am eligible, my lord.
yes, Mr. Mahapatra, what do you say?
Well, in fact, I have not seen that judgment of the. He has not given the copy. Today,
This is in the review petitions filed. Similar review petitions filed by other employees.
my lord.
And both review petitions have been allowed.
Then, my lord, your lordship, may I know the review petition number and your lordship pass on?
All right. This court has been shown copies of the orders dated 25th April 2018 in review petition number 44 of 2018, bracket Umakanta Raut versus State of Orissa, and the order dated 20th July 2018 in review petition 141 of 2018, bracket Krishna Prasad Sahu versus State of Orissa, where following the decision of the Supreme Court in A. Francis versus Management of Metropolitan Transport Corporation, Tamil Nadu, 2014, 13 SEC 383, and State of Punjab versus Dharampal, 2017, bracket 2 ILR Katak 728, bracket SC. This court has reviewed the earlier order passed and granted the relief of requiring the opposite party state to pay the petitioner the differential salary for the post of headmaster for the period from which the ad hoc promotion was granted in a stopgap arrangement till the date of superannuation. Till the date of the date from which the petitioner was officiating as headmaster till the date of superannuation, paragraph. In that view of the matter, the order dated 12th September 2017 passed by this court in the first matter, writ petition civil 19366 of 2009 is reviewed and a direction is issued to the opposite parties to pay the petitioner the differential salary from the date on which he was officiating as headmaster till the date of superannuation. The review petition is disposed of. The same.
My lord, as order also with regard to that the delay has to be fast condoned thereafter.
Yeah, delay condoned and this. All right.
Right.
Both matters, is it? There are two matters or one?
One, my lord.
One. Okay.
One matter.
Obligation.
All right.
And our court.
What's the delay?
Item, it's 46 days.
All right.
This is a matter seeking review of the order dated 29/8/2019. If your lordship will look at that order at page 10, that order is based on an additional affidavit filed by the management, even though there was an agreement during the conciliation proceedings. The agreement is binding on them. And if your lordship will first look at that order, which is thought to be reviewed, if your lordship will look at page 11, your lordship has it?
Yes.
An additional affidavit, second paragraph, an additional affidavit has been filed by the opposite party superintendent, archaeological chemist in Archaeological Survey of India, Science Branch, Bhubaneswar, wherein it has been stated that no scientific conservation work has been executed at Bhubaneswar from the date of award. However, other scientific conservation works carried out in the office after the award so-and-so temple committee. Since the petitioner is from Bhubaneswar, he has not been engaged. All the workers are executed through outsourcing agencies. It is further stated that there is a proposal of 3 additional work executed at Bhubaneswar during financial year 2019-20, and details have been stated in paragraph 8 of the affidavit. That is work at Lingaraj Temple, Bhubaneswar, Khandagiri, Udagiri Caves, and Rajanani Temple, Bhubaneswar, and tender process is continuing and on being completed. The engagement of the petitioner shall be taken on priority. The work will start in the first week of October 2019. The opposite party management to engage the workmen of the petitioner when this work will start in the first week of October on priority basis and furnish such statement before the court as and when necessary. Now, if your lordship will just look at the agreement which is in the writ petition at page 11, that is the agreement which was executed during the conciliation proceeding.
No, but Mr. Mishra, just tell us, this is an order of 2019.
Yes, my lord.
And we are in 2022, and there has been no stay.
They have not been engaged as on date.
No, they have not filed any contempt, nothing.
No, my lord, we are aggrieved by this order. Therefore, we wanted a review of this order.
No,
because
you
there
didn't
is-
get a stay. No,
there
Mr.
is
Mishra, you simply filed a review, you did not get any stay here. So you were bound to comply with that order. Till it is stayed or set aside, you are supposed to comply with it, correct?
No, my lord, I am for the workmen.
Ah, okay. So
And
they've
for
not
the
implemented. No, but why is a review? Why are you filing a review then?
My lord, there is a settlement during the conciliation proceedings, and as per the mandate of the Act of ID Act, this settlement is binding on all the parties. It is as good as an award, and that is the judgment of the Supreme Court in various cases, that you cannot shy away from your settlement. And just have a look at the settlement.
No. But there is a failure report as far as the settlement is concerned. That's what the order records. Come to the earlier portion.
No, my lord. I just tell your lordships, the settlement was executed first. They did not comply with the settlement, and that's why we went once again back to the conciliation of officer. The settlement failed.
Yes.
And then it was referred to the labor court.
All right.
Once there is a settlement, your lordships are conscious of section 18 of the, if I may just take your lordships to the act, before there are judgments of the Supreme Court which are passed on to your lordship. Before that, your lordship will just look at section 12(3). 12(3). Section 12(3).
No. For the last 3 years, when they did not implement this order, you did not file a contempt.
No, my lord,
This order grants you the relief of being engaged on priority
engaged from
basis.
2019. From 2019.
Yes, on priority
Have a
basis.
look at
No. What happened when they did not implement this order?
My lord, we immediately filed. There's a delay of 46 days. We immediately filed the review.
No, but
the review has
how
been-
does it help you, Mr. Mishra? Thing which,
My lord,
your workmen are sitting idle.
My lord, I am aggrieved by that order itself. Your lordship will look at that. If I would have filed a contempt, that order would have been implemented and we would have been engaged from 2019, whereas the settlement was for 2015. And the settlement has a binding effect. That's what your lordship says, that it is better than an award. And in fact, the Supreme Court has held that in a catena of cases. Today, if we have to have the contempt, that means we are satisfied with that order of your lordships, which is sought to be reviewed now.
Yes, what do you want to refer to?
Now, just have a look at section 12(3). Your lordship has it?
Yes.
If a settlement of the dispute or any of the or of any of the matters in dispute is arrived at in the course of the conciliation proceedings, the conciliation officer shall send a report thereof to the appropriate government and so on. And now just have a look at section 18. Your lordship will look at section 18. Persons on whom settlements and awards are binding. A settlement arrived at by agreement between the employer and the workman, otherwise than in the course of conciliation proceedings, shall be binding on the parties to the agreement. Now just look at clause 3. A settlement arrived at in the course of conciliation proceeding under this act, or in as so and so, or so and so, which has become and shall be binding on all the parties to the industrial dispute. Now C, clause C, where a party referred to in clause A or clause B is an employer, his heirs, successors in respect of the establishment to which the dispute relates. Now just have a look at the settlement which was arrived at during the conciliation proceeding, which is, your lordship have it at page 11 of the writ petition. Your lordship has it?
Yes.
Page 11 of the writ petition. This
Yes.
was a settlement arrived at during the conciliation proceedings.
Yes.
Now, your terms of settlement. The management will provide work to the casual after week of May 2005. The workers will be provided work at least 20 days a month. Due to want of administration, so-and-so could get any work during the full day of work of April 2000 will be adjusted during the next 11 months. The place of duty in case of so-and-so will be so-and-so. Now, if your lordship will turn the next page. At page 12. Your lordship has it?
Yes.
Now, the first party is the management. The second party is the president of the union. And if your lordship will look at the last one, this is the regional labor commissioner. This is a tripartite agreement. And this settlement was not worked upon by the management, for which we raised another industrial dispute, and that is where the conciliation proceeding failed. And that is why we are before your lordships that they, on the basis of an additional affidavit.
No, but why? I thought the award in the second round, the award was in your favor, wasn't it?
No, my lord, it wasn't. The tribunal says I do not have jurisdiction, in spite of the fact that they came before the conciliation officer, entered into another.
No, come to page 23 in the writ petition, para 10.
Yes, my lord. Yes. But before that, just have a look at page 22.
All right.
I am of the considered view that the tribunal is lacking jurisdiction. Now, once they enter into it, that is it. It's a sacrosanct. It's a document.
Just read the whole sentence, please. I think you have to read the whole paragraph for the discussion made above. Read the whole paragraph.
For the discussions made above and keeping in view the totality of the pleadings and evidence advanced by the parties, it can be said that the disputed workmen, having not been for a period of 240 days in a year, and their appointment being intermittent, subject to availability of the works and sanction of funds towards preservation and maintenance of the monuments, and in view of the findings in supra, that doubt can be entertained whether the management is covered by the term industry, and in view of the settled position of law that the tribunal cannot direct or should be slow in giving direction for absorption of regularization of service of temporary when sanction of course are wanting so and so, I am of the considered view that this tribunal is lacking jurisdiction.
Yes.
this tribunal is lacking jurisdiction to give any specific direction to the management.
Yes, just read on, please, to engage.
Sorry.
Continue reading, please.
Is lacking any special to the management to engage the disputed workmen directly as casual laborers in the chemical division throughout the state and provide them work throughout the month. And as such, the action of the management not engaging the laborers directly in chemical through the state of Orissa and not giving full back wages to 30 casual laborers cannot be declared by this tribunal as illegal or unjustified. Now just have a look at the next paragraph. In view of the commitment made by the management for providing at least 20 days work in the disputed workmen in the settlement so and so, the management should consider the demand of the disputed to take up to address their grievances, because the settlement is sacrosanct. That is what the judgment of the
No, but tell us, no, Mr. Mishra, I don't see there being this is a ground for appeal. See, the tribunal did not agree with you. This court, you challenge this award, did not entirely agree with you, but both the tribunal and this court
agree, because if you're
both the tribunal and this court asked them to engage you people for 20 days and a month. Projects which were commencing from October.
No, my lord, but then the agreement goes for a wash. The entire settlement.
That's the decision. See, there's no question of a review. We don't see how there's a ground for review. All the grounds that you are urging now, you urged before the tribunal, you urged before the High Court. Neither agreed with you, and a judgment has been given. We can't be hearing an appeal against our own order. This may be a good ground for an appeal, but not for review.
Can I just show your lordship's page 10 once again? The order which has been challenged. Once again, if your lordship will just go to page 11 of that order.
Right.
The High Court doesn't take it into notice the settlement at all.
Yes.
The settlement has not been taken into notice by the High Court. It is only the additional affidavit which has been taken into notice.
Right. No. In fact, the third paragraph, the petitioner union approached the labor authorities and has disengaged with the management. The settlement was arrived at. They are starting off by noting the settlement. So, anyway, you say no grounds are made out for review. The review petition.
Yes, but they have not discussed it. They have just completely ignored it. Settlement has been completely ignored.
Delay is condoned. Thank you, Mr. Mishra. Right.
All right.
All right.
Along with me, Jateshwar Naik.
All right.
I don't know if I
May I please your lordship, my lord? This PIL
Asked me to take instructions for that water disconnection.
Right.
So what has happened actually, while trying to widen the road and remove the encroachments, JCB, the drivers of the JCB inadvertently have dug up the water.
Oh.
It's not deliberate.
No, but when are you
What I explicitly instructed, and they have agreed from today they are going to supply tankers immediately. And within the next 5 days, by coordinating with Vasco, they will restore the connection.
So we'll keep this pending. You restore it. You say, Mr. Naik, learned counsel appearing for the Cuttack Municipal Corporation, while undertaking the road expansion work, the JCBs accidentally removed the water pipelines, as a result of which the water connection to the residents of the 3 localities got disrupted. He assures the court that from today onwards, special water tankers are being arranged for supply of water to the 3 areas. Which is what? Which are the 3 areas?
my lord, only Tulasipur, Hattigada, Basti, my lord.
Tulasipur.
That's one locality.
One locality.
No.
That I have mentioned.
Hathigada. Tulsipur and Hathigada Basti is one.
One.
Okay. So the Tulsipur, Hathigada Basti. Which are the other 2? Only one, is it?
Only one.
All right. And within 5 days, the regular water supply will be restored. Full stop. In view of the above assurance, list this petition on December 16th.
Lordship, I mean, pardon to mention, Lordship, I am in virtual mode. Lordship, I have mentioned this matter before this honorable court. I have filed an interim application, entire Cuttack town lordship, they have their new water line. So in CDA, what they have done on pick and choose basis, they have connected this new water channel line at the across the sectors lordship. That intervenor application is there. That is IA number 16912 by 22 lordship. This may kindly take along with that on your lordship next date. IA number 16912 by 22 lordship.
I don't think we'll put it have it listed with this. Tell the registry to list. And you give a copy of this to Mr. Naik.
Copy to
I was just saying, my lord, that these new water connections that are now being put up are basically by Watco. So Watco.
Oh, Watco. You'll have to serve Watco.
Lordship, the copy I have submitted to Watco, Chief Executive Officer, then the General Manager and SDO of Watco. I have served the copy with them. And the Commissioner of Municipality Corporation, Lordship. Because Commissioner of Municipality Corporation is now taking over the entire.
Yeah, actually, he says it's a different because the disruption to Tulsipur and Hatigada is different.
Lordship, the Commissioner Municipality Corporation Cuttack has taken over the activities.
Mr. Biswal, maybe you should file a substantive writ petition, a separate one. Just simultaneously file, you withdraw this IA and file a separate one. You file a separate substantive petition. We'll have it listed next week. All right.
Lordship, filing in.
I don't see X.
6, my lord. I am for the petitioner, my lord. My lord, as per your lordship's order dated 4/11/2022, the Bhadrak District Legal Service Authority Secretary visited to the spot, my lord, and submitted the report, my lord. Your lordship may kindly have a glance on the report of District Legal Service Authority Secretary.
They've just put the cover sheet. They've not enclosed. They've not scanned the report. Only the cover sheet has been scanned. Flag R, please. They've not scanned the report. Please note, we have to scan the entire report. Have you got a copy of the report?
Yes, my lords.
Ah.
My lords, if I may.
Yeah.
If my lords.
Tell what,
yes,
what is it? Huh?
My lords, there is a letter dated 17/11/2022 by the office of the Panchayat Samiti, the address to the secretary, where if I may read the second paragraph. My lords doesn't have the report. I will just.
Which page of the report?
Well, is it? This is probably an internal document. If I can just, where my lords, they have said that they will start the work from 18/11/2022 itself. If I may, my lords, just pass on the letter.
Millard, though they have written in that paragraph, Millard, till now no work has been started, Millard. It is only to escape themselves from the liability, Millard. Simply they have written it and now no work has been started.
As the BDO has written the letter, my lords, I'll file a.
Which letter? We're not. Which is this letter?
My lords, it's, if I may pass, it's probably an internal instruction, my lords.
No. What has he written? When did he write?
My lords, he has written it on 17/11 after the visit.
After we pass the order.
My lords, may I, my lords, read the. After your kind visit, along with CDO come EO Bhadrak, the project, namely construction of Luni Pokhari of KKpur GP from 5th SFC 2021-2022 will be starting from 18/11/2022, and as the water level of the pond is high, it will take 3 to 4 days to dewater, and renovation of Luni Pokhari will be started out of Manrega, MGNREGS. The next page, that another project, namely construction of guard wall of Luni Pokhari from 5th SFC 2020 to 2023 will be started receiving the second installment of 2020 to 2023. Further, the Sarpanch and PEO of Kekepur GP reported that they will start the project positively, ensure the completion, and if in future there will be any obstacle by the villagers, then the appropriate legal action will be taken against the offenders for implementation of the order of the Honorable High Court. This is, my lords, written by the BDO of Basudevpur.
What is the answer? I don't know. Today we are on 9th December.
Yes, my lords.
The person, you heard him say nothing has happened.
Nothing, Millard. They have not.
1 minute, Mr. Parida. We're already, Mr. Parida.
Millard.
Without asking you if you're going to start arguing, then we will stop. You do the arguing. We'll go on to the next matter.
Sorry, Millard. Sorry.
We're asking him some question. You're interrupting.
Millard, sorry.
My lords, I'll take instructions from the BDO. The BDO will file an affidavit, whether it has started or not, and when is the completion date of the of this project, my lords. I'll file an affidavit within 2 weeks, my lords.
You say the court has perused the report dated 21st November 2022 of the Secretary in charge, District Legal Services Authority, bracket DLSA, Bhadrak, who visited the site with prior notice to the Block Development Officer, bracket BDO, bracket Basudevpur, and Collector Bhadrak, as well as the Project Director, District Rural Development Agency, bracket PD, DRDA, bracket Bhadrak, as well as the Sarpanch of Kismat Krishnapur GP. Full stop. The three projects, full stop. According to the BDO, therefore, 3 projects have been taken up at the GP level, i.e. 1 5th SFC of rupees 5 lakhs for 2021-22, 2 5th SFC of 5 lakhs for 2022-23, and MGNREG scheme of rupees 10 lakhs for 2021-2022. Full stop. It was admitted that construction of the guard wall would not be started on account of the protest of the local villagers, but an assurance was but the Secretary DLSA impressed upon them to start the work immediately without delay. Paragraph, enclosed with the report are certain photographs, as well as the detailed project reports. Paragraph. Mr. Ishwa Mohanty, Learned Additional Standing Counsel, refers to a letter written by the BDO to
BDO Basudevpur to the Secretary DLSA Bhadrak.
To the Secretary DLSA on 18th.
On 17/11.
On 17 November 2022, assuring that the work would start from 18th.
Yes, ma'am. 18/11/22.
18/11/2022. Full stop. Obviously, the said assurance was not adhered to, since the report is dated 21/11/2022, and the report states that no work has yet started. Paragraph. In addition, Mr. Parida, Learned Counsel, the petitioner, states that even as of today, that is 9 December 2022, no work has commenced. Full stop. Clearly, the assurances held out are not being adhered to by the authorities. Paragraph. A specific direction is now issued to the Collector Bhadrak, the PD DRDA Bhadrak, and the BDO Vasudevpur to ensure that the work on construction of the guard wall commences without any delay, latest by 12th December 2022. Full stop. A report of compliance with this direction be placed before this court before the next date, with indicating the status of construction along with photographs. Full stop. If the above direction is not complied with, the BDO Vasudevpur as well as the PD DRDA will remain present either in physical or virtual mode before the court on the next date. Paragraph. A copy of this order will be sent forthwith by the registry to the Collector Bhadrak, the PD DRDA, and the BDO Vasudevpur. Additionally, it will be the responsibility of Mr. Monty ASC to ensure that this order is immediately delivered to the three officials for ensuring strict compliance. List of 17 January.
Item 7.
My lord, in item number 7, I think Mr. Mahanti has some difficulty today. And for the petitioner, I've given to understand Mr. Pradipta Mahanti has some difficulty today because he
I
has
see, yes, all right. It is
short
stated that Mr. Mahanti and senior counsel for the opposite parties in some personal difficulty. List on.
any day in
Is there
January.
an interim order here?
The Lordship, we have complied with the interim order and pleadings are also complete. Interim order was there to deposit the entire amount. We have already deposited.
All right.
Lordship, may see the last order 16/12/2021.
Yeah, 20th March. 20th March. Right.
Lordship.
8.
Please, your lordships. Your lordship, in item 8, in the last occasion, your lordships were pleased direct the state directing that the petitioner may be permitted to remove the furniture and other movable assets in the shop in the presence of the officers of the department. White order dated 18/11/2022, your lordship. In IA number 12077
What
of
happened?
2022.
We have filed the affidavit, your lordship, my kind. On 1st December, I have given copy to the other side also. Para 4.
There was nil stock.
Yes. FIR was lost, the IIC has seized locked the, so the excise department is no way responsible to unlock it or hand over the materials. It is in a police case, in connection with a police case, because some incident happened in that premises for which it was locked.
I
So
see.
the IIC commando is the right person to unlock it, or by inventory, he is entitled to get all these things. I don't, but so far as the excise authority is concerned, we are
All
not.
right. In view of the affidavit filed, affidavit dated 1st December 2022, filed by the Superintendent of Excise Bhubaneswar, a notice is issued to the inspector in charge,
Commando PS,
Tamando Police Station,
Bhubaneswar.
in connection with FIR number 221 dated 22/10/2021. As the shop appears to have been sealed at his on his orders. Full stop.
During the course of investigation of that case.
Yeah, sealed on the orders in the said case. Full stop. Paragraph. The notice be delivered. You see, the process fee for this notice will be filed by the petitioner within 3 days. Notice be delivered by special messenger to the IIC Tomanda PS, who will
File affidavit, will file.
file an affidavit and instruct the standing counsel, additional government advocate on the next date.
Your lordship, I am also filing IA for impletion of IIC Tomando is opposite number
Oh.
5. If required,
Then that can.
All right, that I is taken on board, allowed. List on 17 January.
Can you let's see, take it week commencing 21st? Because my senior will be arguing this matter and he is in accommodation. Your
So
Lordship.
what is this in? You can do it.
Yes, nothing.
Once the
just
police is
shop is
coming, it
specially
can
set.
be
All right,
opened, I
anyway,
think.
All right, 30th January, 30.
Obliged, Your Lordship.
Defects be removed within a week, list thereafter.
3,
Same, I think both matters.
4,
My lord, sir, deficit postage has already been paid, my lord.
When did you file it? When did you pay it?
Today, my lord.
Today, all right.
Let it be placed after the stamped postage.
All right, it is stated that deficit court fee has already been paid today. list after the stamp reporting is complete. All right.
5,
Five also deficit would be paid today.
Same order here in 5 also. All right.
6,
Your 6, my lords, on the last occasion, this is the arbitration matter coming from the tribunal, from the Australian arbitration, Odisha arbitration tribunal. This order has been passed by lords.
With so many defects, civil copies and all not filed anyway.
Lord, Dr. Rotho, Justice Rotho has appointed in another proceeding.
Same day.
Same.
All right. Same order. Disposed of. All right.
7,
May I please your lordship?
Yes.
The arbitration agreement is at annexure 2, page 16. The clause is at page 18, clause 25.
All right. Notice, Mr. Party accepts notice. Reply within 4 weeks, rejoined for the next date. 27th January.
item 8,
My lords, may I please, I'm appearing for the petition, my lords.
Mediation successful, it says.
My lords, no, my lords, just one submission in this regard, my lords. As per the mediation, they were to pay us an amount of 1,77,22,243 rupees. So out of that, they have deducted a TDS of 10% and submitted, transferred 1,59,50,018 rupees. Now, my lords, according to, since this is a payment towards the interest, my lords, and once they have deducted TDS, now GST becomes payable on this. We have been demanding them to pay that 5% GST to us, which is an amount of 8,86,112 rupees, for which they can also get a debit note from us. But that amount has not been paid.
on that date, when the mediation sitting happened, successful and hold the butter to this amount.
No, I know, but they must not anticipated that you will not pay the GST. All right. Counsel for the opposite party states that although pursuant to the settlement arrived at the mediation center, payment has been made, but it was only to an extent of 159. What is this?
1,59,50,018.
159,50,018 was paid by the
After
petitioner.
deduction of 10%.
After deduction of 10% towards tax deducted source. Full stop. It is stated that the opposite party is now liable to pay GST to an extent of rupees 5.
5% on the settlement amounts, which is 1,77,22,243 rupees.
On the
And
all
that
right,
amount comes
5% of the settlement amount of rupees 177,22,243, and this should be reimbursed to petitioners. Paragraph Mr. Das, learned counsel for the petitioners, seeks time for instructions. List on 23rd January.
deeply obliged.
See,
9,
another,
Sorry, 20th January. 20th January. Sorry. Yes.
My lords,
item
here,
9, another counter has been filed today.
and a rejoinder has been filed, a copy whereof has been means given to us just right now, my lords.
Your lordship must fix a short. It's been-
Lord, otherwise it will reach its anniversary in any case after the vacation. This will be lost out, like already 1 year will be there. So any subject to your lordship's convenience, any shorter date.
Or at next Friday, at the request of Mr. Mukherjee, list on 16th.
Okay. Okay.
My lords, next Friday will be problematic.
23rd.
23rd.
All right, list on 23rd.
Deeply obliged.
10,
Lordship. The mediation fees, your lordship, to 18, mediation continue, lordship, 18/1/2023, your lordship.
All right, the mediation is in progress. List on 27th January.
Obliged.
11,
Lords, they have filed a counter, my lords. The counter, 2 grounds have been taken. One is settlement, second is limitation. On what can be adjudicated by this honorable court. Now, limitation ground, my lords, the settlement agreement was signed on 16/6/2018. And I issue my letter of that I am under duress. I've signed the settlement agreement under duress after 8 days of the letter. So I have, and that letter I have pointed out what I was under, how I was under duress. Now, duress has to be adjudicated by the honorable arbiter. Now, my lords, I issue my letter invoking on 22/3/2021. That is within 3 years. And also within the period of COVID period. So
I'm
that
sorry
period
for
of-
interrupting him, my lord.
recently we have been admitted under the IBC. So I'm not very sure.
Oh,
Because I have a moratorium period proceeds against the executions, not against the arbitration proceeding per se.
no, all proceedings everywhere, please. It's not only against execution.
Yesterday evening we got
all proceedings everywhere come to a halt.
actually 2811, they have been admitted. The moratorium petition has been
Then that's the end of the matter. You say it is stated that the opposite party is before the National Company Law Tribunal and has been passed on
that yesterday I got. So I'm not
imposing a moratorium on all proceedings against the said company.
It kept on pending.
No, we will revive it subject to the orders of the NCLT. The petition is disposed of with liberty to the petitioner to revive it, subject to the orders of the NCLT. Right.
Let it be kept pending. I will get me.
Not necessary, Your Honor, sir. Right.
Well, I can tell you I have already. By Monday, I'll find the country.
On it, counter affidavit. Counsel, the opposite party assures that counter affidavit will be filed within 2 weeks. Rejoined for the next date. 13th January.
Captain, may I please, my lord?
My lord, I'm appearing on behalf of Mr. A. Crowd. Can you have a glance at order number 3 dated 28/10/2020?
Counter not filed.
My lord, I'm filing the counter. My lord.
Counter is being filed today. Rejoinder will be filed before the next date.
Copy to
20th January.
A copy may be served.
Copy.
I'm obliged, my lord. By next week, you'll file the count.
All right. Counsel for the opposite party assures that counter affidavit will be filed by next week. Rejoinder before the next date. 27 January.
Obliged, my lord.
Let it come earlier, some earlier date may fix, my lord.
What difference does it make, sir? 27th is within a month.
My
No
lord.
problem. It's all right. It's all right. Yes.
My lord, Mr. Kashyap may along with me, Mr.
All right. All right.
Place admission. I don't want.
My lord, item number 1 that
My lord, I will raise all the point of the.
All right. Permitting the petitioner to urge all the pleas at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated. What is this conducted writ petition?
that writ petition I have challenged the caste certificate, the order issued by the state level commission that regarding my caste, man.
All right. Let this go before the roster bench. List
Go to the
roster bench. List before the roster and the connected petition. List before the roster bench on 18 January, interim order to continue.
I don't know.
None appears.
Pray.
The interim order is.
Your Lordship, item number 2.
Yes,
May I please, Your Lordship, I'm appearing for the Bastan Das.
yes.
Your Lordship, very limited prayer. I may be permitted to withdraw the said application and renew after the framing of charge.
All right. Permitting the petitioner to urge all the pleas at the appropriate stage in the trial court. The petition is disposed of.
Obliged.
Interim order is vacated. All right.
Pray.
Lord, may I pray, my lord, let it be taken up next week, my lord, next Friday, my lord. I could not contact my clients, my lord. They are senior officers of Coal India Limited, my lord. They have been transferred to different places in the meantime. Lord, the offense is technically in nature, but violation of Mines Act, my lord. And my lord, I have to
Permit them to take all the pleas at the appropriate.
Lord.
Permitting the petitioners to.
No, my lord, your lordship may kindly permit me to argue this case, my lord.
Yes.
My lord, the petitioner, my lord, petitioners are, my lord, general managers of, my lord, Mahanadi Coalfields Limited at the relevant time, my lord. Lord, what happened, my lord? Some outsiders, my lord, they came to the show of the overburden, where the overburdens are stacked, my lord. There, my lord, there is a open cast mines, my lord. And the overburdens, the earth and topsoil, they are extracted, my lord. And they are done, my lord. And these outsiders, they came inside inside the campus, my lord, unauthorizedly. And my lord, this overburden slid and they were buried under the earth. And 13 persons died, my lord. And thereafter, the mine safety, he initiated this prosecution, my lord, under some, my lord, and the cognizance was taken, my lord. under section 70, my lord, under section 72, 73, 72A, 72C, 1A of Mines Act, my lord. And my lord, for violation of section 18(4) of the Mines Act, my lord. Your lordship may kindly see, my lord, I am challenging this, my lord, on the ground that section 75 has not been complied with, my lord. Section 75 of the Mines Act says, my lord, your lordship may kindly see, section 75 of the Mines Act, my lord. No prosecution shall be instituted against any owner, agent, or manager for any offence under this act, except at the instance of the Chief Inspector of District or of the District Magistrate, or of an inspector authorized in this behalf by the General and Special on writing by the Chief Inspector, provided that the Chief Inspector or District Magistrate or the Inspector, as so authorized, shall before instituting such prosecution satisfy himself that the owner, agent, or manager had failed to exercise all due diligence to prevent the commission of such offence, provided that in respect of an offence committed in course of technical direction, management of a mine, Lord District Magistrate shall not institute any prosecution against an owner, agent, or manager without previous approval of the Chief Inspector. My submissions are threefold here, my lord. I attack this order on 3 grounds. First, my lord, there is infraction of 75 mines of this section 75 of the Mines Act. Second, my lord, the board of directors, my lord, directors has not been made a accused. My lord, they are the owners of the the company under section 291 of the act. My lord, third, my lord, the investigator has become the prosecutor, which is not permissible under law. Your lordship may in this context, my lord, see a judgment of my lord Andhra High Court, my lord. Lord, this 75 has been considered, my lord. The lordship may kindly come to para 5. Adverting to the said contentions, section 75 of the Mines Act 1952 reads as follows. My lord, section is quoted, my lord. Thereafter, it is clearly mentioned under section 75 of the act that before sanctioning prosecution, the Chief Inspector shall satisfy himself that the owner, agent, or manager had failed to exercise due diligence.
No, but there factually it says no order has been passed under this section by the Chief Inspector.
My lord, that is only the ground, my lord. That is the only ground I have challenged, my lord. That is the main ground.
Counter affidavits.
My lord, no order has been passed. No order has been stated to be passed in the complaint. Your lordship may kindly see the complaint for the time being.
No. Come to para 8 of the counter affidavit.
My lord. Para 8 of the complaint, my lord.
Of the counter affidavits.
Para 6, my lord. Para 8 of the complaint. In the complaint, my lord, para 4.
So we are on the counter affidavit.
Yes. In the counter affidavit, they have also admitted.
Para 8.
Para
Please
8.
come.
Sorry. Para 8, my lord. In reply to ground number 2 of the criminal miscase is not correct and hereby denied. It only submitted that requirement under provisions of 75 of the Mines Act 1952 was with as the complainant being the director of mine safety as well as inspector of mines had already been authorized to institute a case under section 75 of the Mines Act by virtue of general authorization published in so and so. Before launching the case, the complainant being inspector of mines satisfied himself that the delinquent person had failed to exercise their duties as enshrined under section so and so of the and different provisions of Coal Mines Act, and same has already been mentioned in the complaint petition. Lord, there is no mention, my lord. Your lordship may kindly peruse the complaint petition.
All this can be examined with the trial.
My lord, your lordship may kindly see they have to pass a specific order, my lord, before initiate.
That's the trial court will examine the record and pass appropriate orders.
Now the petitioner number 1 is, my lord, the director of Western Coalfields Limited. He is posted in Madhya Pradesh.
All right.
Your lordship may kindly consider their position, my lord. Your lordship may kindly see, my lord, this part of judgment I am placing, my lord. The para, my lord, 5, my lord, para 5. It is clearly mentioned under section 75 of the Act. Before sanctioning prosecution, the Chief Inspector shall satisfy himself that the owner, agent or manager had failed to exercise due diligence to prevent commission of such offence. No such thing is mentioned in the complaint. It is clear that while satisfying himself, the chief inspector has to give his order for coming to the conclusion that due diligence was exercised. No order has been passed under this section by the chief inspector or his authorized persons. There is much force in the contention of senior counsel so and so. In the absence of the same, the prosecution is not maintainable. My lord, in this case, my lord, no order has been passed. My lord, nothing is mentioned in the complaint that such order has been passed. Therefore, this judgment squarely applies to the facts of the case, my lord. Therefore, the complaint is not maintainable, my lord. My lord, this is technical offence, my lord. They are unauthorized persons. Section 48(6) prohibits, my lord, outsiders cannot come to that area, my lord. We have put up the fence, my lord. My lord, the only ground, my lord, they have stated we have not adequately put up the fence, my lord. Fence is there, my lord. We have put up barbed wire fence. We have, my lord, posted the, my lord, fixed the notice board, my lord. But trespassers will be prosecuted. Thereafter, my lord, they have come and collected the remnants of coal, my lord, to earn a little money, my lord. And my lord, the only ground, my lord, the suitable fence. The language is suitable fence. Your lordship may kindly come to page 16 and the allegation, my lord. Failed to ensure that a suitable fence erected to prevent the unauthorized persons, my lord. We have erected barbed wire fence, my lord. It is not possible to erect, my lord, 20 feet wide, my lord, wall, my lord. Therefore, my respectful submission is, my lord, this complaint is not maintainable. My lord, they are senior officers. My lord, the complaint is, the offence is technical in nature. They are not involved, my lord. And my lord, the director is not present in the complaint, my lord. Therefore, the complaint is incompetent. Your lordship may kindly consider and exonerate these persons, my lord. Without, my lord, they are the senior officers. They will face harassment. They will come from different, my lord, positions and, my lord, before this court. My lord, this is my submission. My lord, your lordship may kindly consider.
The 5 petitioners who all hold managerial positions in the Mahanadi Coalfields Limited have filed this petition seeking the quashing of a complaint case 2CCC number 9 of 2014 in the court of the subdivisional judicial magistrate (SDJM) Sundargarh, as well as the order dated 22nd September 2015 passed by the said SDJM, taking cognizance the offences under sections 73, 72 capital A, 72 bracket C, bracket 1, bracket A of the Mines Act 1952 against the petitioners. Paragraph. The above case was registered on a complaint by the Inspector of Mines appointed under section 5 of the Mines Act 1952 arising from a fatal accident at the Kulda OC mine, village Balinga, PS Hemgir, district Sundargarh, where while salvaging remnant coal from the toe of an external overburden dump of an open cast coal mine, 13 persons died due to serious bodily injuries. Full stop. The complaint lists out numerous violations that were observed when the complainant made an inspection and an inquiry on 11th, 12th, and 13th September 2013 into the causes and circumstances led to the said accident. Paragraph. Inter alia, it is stated that the 5 petitioners herein were at the relevant entrusted with the oversight of the mining operations and strict compliance with the provisions of the Mines Act 1952, as well as the rules, regulations, and orders made thereunder. Paragraph. Then it comes to the petitioner on the basis of the judgment of the Andhra Pradesh High Court in NV Subramaniam versus State, bracket Government of India, bracket 2002 Criminal Law Journal 3264 argued that in the present case, no order had been passed by the Chief Inspector or his authorized person regarding the subjective satisfaction that the open quotation owner, agent, or manager have failed to exercise due diligence to prevent the commission of the offense, unquote. Full stop. According to him, the complaint itself does not record such satisfaction. Paragraph. In the present petition, while issuing notice on 8th April 2016, the further proceedings in the above case before the SDJM was stayed by this court. Paragraph. In reply to the in response to the notice, a counter affidavit has been filed by the Inspector of Mines, Chaiba region, inter alia, stating in para 8 as under, reproduce internal page 2, para 8 of the counter affidavit. Paragraph. The question whether there is actual satisfaction recorded of the failure by the petitioners to exercise due diligence to prevent the commission of the offense is a matter that has to be gone into by the trial court. So it appears to be a disputed question of fact. Full stop. Unlike the decision in NV Subramaniam, Supra, where the High Court records that, open quotation, no order has been passed under this section by the Chief Inspector or his authorized person, unquote. The same cannot be said of the present case in view of the above argument in the counter affidavit. Full stop. This being therefore a disputed question of fact cannot be plausibly adjudicated at this stage in these proceedings. Paragraph. Permitting the petitioners to urge all the pleas that they may have in accordance with law, including the points urged in the present petition at the appropriate stage before the trial court. This court declared at this stage. The petition is accordingly dismissed. The interim order is vacated. Right. A copy of this order be sent to the concerned trial court forthwith.
Item 4. Your Lordship, in item number 4, I pray for an adjournment, Your Lordship, because my senior is in accommodation, Your Lordship.
No accommodation is for you. It's not for us. What's the reason?
Your Lordship, my senior will be arguing the matter.
No. That is not a reason for an adjournment, sir.
He is in.
It can be a thing for Passover. We can pass it over.
No, he is in personal difficulty, Your Lordship. His uncle is ill. That's why. I am
say
praying
that.
for an
Don't simply say accommodation there. Concept of the petitioner is stated to be in some personal difficulty.
Your Lordship, interim orders to continue, Your Lordship.
List next Friday. 16. Interim order to continue.
Obliged.
Item 5.
None appears dismissed.
6.
Interim order is vacated.
Made PG Lordship, I am appearing on behalf of Mr. Sambit Manti, learned counsel for the petitioner. Lords, I am submitting written note of submission and equivalent citations. Lords, in the present case, we are seeking quashment of proceeding by GR case number 241 of 2015, pending before STGM Jagat Singh Court. My lords, there were 6 people named in the were made as an accused, in which 5 have been acquitted by the learned CJM Jagat Singhpur on dated 3/3/2016. So, my lords, the present petitioner was made an accused on the as a conspirator to the alleged offense.
So all the more, sir, you just have to go there, you get acquitted on these grounds. In fact, had you allowed the trial to go on in your case, you would have got acquitted by now. You shouldn't have come here and got a stay. You prevented the trial court from acquitting you. That is your problem. Counsel, the petitioner urges that since the co-accused have all been acquitted, the case against the present petitioner should be quashed. Paragraph, the case against the present petitioner could not proceed because of the stay order passed by this court. Full stop. But for the stay order, it is possible that judgment would have been passed by the trial court in the case of the petitioner as well. Paragraph. Consequently, permitting the petitioner to urge all the pleas available to him in accordance with law before the trial court, the petition is disposed of, the interim order is vacated. A copy of the order be sent to the concerned trial court forthwith.
Seven. May I please, your lords, on behalf of Mr. F. Bose, my lord, the petitioner challenged the order passed by the London court rejecting the discharge application filed under section 227 of CRPC and framed charge under section 498, 323, 506, 34 IPC and under section of the Prohibition of Child Marriage Act. The present petitioners are parents and relatives of the main accused, who is not party, not the petitioner here, and married a minor girl, my lord. At the time of marriage, we are not present and we do not have any knowledge. Kindly see, my lord,
Difficult to believe that, sir.
Page 29, kindly see. In a cross-examination report, paragraph 3. Out of love intimacy, we both decided to marry each other and accordingly marriage had taken place. Both side parents did not consent for such type of marriage.
What are you reading?
Page 29, my lord, the cross-examination of the victim.
So the trial court will deal with all this. Why should we interfere at this stage, sir?
The charge has been framed under section 10 of Prohibition of Child Marriage.
So what, relying on this deposition, that whatever the trial court has to do, will do?
That deposition is in the proceeding which is filed under section 125 of CRPC.
We don't have to give you free legal advice how you should deal with all this in the trial court, sir. There's enough provisions in the Evidence Act for all this. Is it permitting the petitioners to raise all pleas available to them at the appropriate stage in the trial court? The petition is disposed of. The interim order is vacated. Copy the order to the concerned court forthwith. All right.
Oh, bless you.
8.
None appears dismissed. The stay is vacated.
9.
Same order.
10.
No instruction.
No instructions dismissed. Interim order vacated.
11.
Matter is influxus.
Infructuous dismissed. Interim order vacated.
12.
None appears dismissed. Interim order vacated.
13.
After registration of the FIR, I have not received any information about any stage of the case.
All right. Counsel for the petitioner states he has no instructions.
No. I don't. I have instruction that my client has not received any information regarding the case. FIR is in law. This is a government servant. But after the FIR, what has happened? Neither the board nor the investigating agency have called for. My client can know what is the stage of the case.
Started already been filed, my lord.
Charge sheet has been filed.
Then I will take
Pursue. Yeah. Counsel for the state informs the court that charge sheet has already been filed. Mr. Mishra then states that all pleas will be urged at the appropriate stage in the trial court. The petition is accordingly disposed.
For that, you will also permit 23 and 75.
Same.
Maybe column not same. Maybe in January. Because 23 I could not trace out the file, and 75 I got the file in the last time. So 70 with I don't know about the 23, 75. It will take some time to get ready. Sometime in January.
23 and 75 say listen for the roster bench on 11 January. All right.
Alright. And 23 also.
Same. All right.
Alright.
14.
Item 14, my lord, here. Order of cognizance is under challenge, my lord.
Yes.
At page, lordship, there is statutory violation of Rule 7, Sub-Rule 1 of the SCA Prevention of Atrocity Rules.
Urge
Because
all the pleas, sir, at the appropriate
the officer not below the rank of DSP is to.
Yeah, all this can be urged. You say permitting the petitioner to urge all the pleas available to him in accordance with law before the trial court at the appropriate stage. The petition is disposed of.
15.
I'm appearing on behalf of Public Monthly Order Council for the Commissioner. This present case, I'm seeking quashment of the proceeding by GR case number 4 A of the court law. Under offenses, being to the section 34 of IPC, read with concern answer. My lordship, kindly go to the last part of the lord. Your lordship directed on the state council to obtain instruction whether the principal accused has been appointed or not?
No, that instruction I have not received. That instruction I have not received. Thus. One chance will be granted. Regarding whether he has been acquitted or not. To sex Asif, whether he has been acquitted or not, that instruction I have to obtain.
Counsel for the state needs some more time for instructions. This move the roster bench on 11 January. Interim order to continue.
16.
Item 16, we have no instruction.
No instructions dismissed. Interim order.
17.
My lord, item 16, my lord, raised on the point quote below, my lord. My counsel by mistake.
Item 17.
17 is it?
Yeah.
Okay, 17 no instructions dismissed. 16 permitting the petitioner to raise all pleas at the appropriate stage.
Obliged to lodge.
Interim order is vacated.
18.
Can you sum down here to Mr. Esma Patra? My lord, here's the challenging the order of charge, framing of charge against under section 406, 409.
Some of these steps to hold a past. Yes,
Here under challenging the charging of frame, my lord, against the section 406, 409.
framing of charge, not charging of frame.
Framing of charge.
Yes,
Framing of charge against under section 406, 409 and 34 of IPC, my lord.
right.
My only contention here that 409 says that punishment for criminal breach of trust by public servant, my lord. And 406 is breach of criminal trust, my lord. So my only contention is that both the ingredient are same, my lord. They must be punished in only one section. Both cannot be applied one.
All this you can take at the appropriate stage, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Copy the order be sent to the concerned trial.
19.
Dismissed as infractions. Interim order, if any, vacated. All right.
20.
Lordship, item number 20, your lordship, may I be permitted to submit on behalf of Mr. S. Ratha?
Yes, yes.
Lordships, under this application, lordship, I'm challenging the notice under section 110 of CRPC, my lord. At the point of time, the petitioner was a government servant. And lordships, Justice Krishna M. Gopalanchari was a state of Kerala has clearly held that all these allegations like habitual offenders, dangerous cannot be leveled against the petitioners with laxity of semantics, my lord. The lordship kindly peruse annexure 4 at 29, page 29, annexure 4. This is the notice that was issued under section 110, my lord. They have not explained why they are calling me habitual offender. There are 3 FIRs. One is under Prevention of Corruption Act. The 2 FIRs, your lordships, may kindly peruse annexure 1 and 2. By going the contents of the FIR, your lordship will be clear that there is no such allegations against me by which I will be called as an habitual offender or something dangerous to the society, my lord. This is all these FIRs, my lords, arose out of due to the installation of a mobile tower in the society. There was a dispute between the neighbors on account of these FIRs have been lost, and they are calling me habitual offender, issued notice under section 110, my lord.
No, but how many FIRs do you have against you?
Lots of 3 FIRs as mentioned, page 30.
So each of those FIRs are the same cause of action? No.
No, my lord.
So it can't be just about mobile tower. It must be something else.
Lordship, the third FIR is under Prevention of Corruption Act.
And then the second one?
Second one is under Lordships, that's 341, 325. Lordship, may kindly peruse the content of the FIR. What's the allegation against me? They are saying 4 unidentified person came and they are believing that I may be the person who is involved. Except
all this can't be examined in a 482, sir. These can't be examined in a 482.
Lordships, what I'm saying, Lordships, leveling me as a habitual offender and dangerous to the society, my lords, that will violate my Article 21, my lords. Whether the FIR holds good or not, Lords, I'm not challenging the FIR. I'm challenging the notice section 110, my lord. The trial court will proceed and
it's just a notice, sir. They've not yet labeled you as an habitual offender. It's just a notice.
Lordship, in this notice, they have not followed the procedure under section 111, my lord. And the case of Mr. Gopalanchari was a state of Kerala. Justice Krishna had clearly held that all those allegations need to be substantiated with the fact before calling me as somebody dangerous to the society.
No, you were in custody. You were in custody since 3rd February 2017.
I was in custody and I have been enlarged on bail, my lord, by the lower.
So 307, sir.
But my lordship, my kindly. See
And
the
you have
particular
SC/ST also.
Lordship,
That you did not
kindly-
mention. It's the first CS
yes,
Chandrasekhar
my lord.
PS 219 is under the SC/ST Act as well.
Lordship, may kindly see the content of FIR. In this record, my so let the lower court will proceed on merit. I don't deny that, my lord. I'm just challenging notice under section 110, my lord.
Yes.
If I have done some wrong, lordships, the lower court will go on merit. I don't challenge all those three FIRs.
Yes.
But this 110 should not be invoked so easily just to curtail my liberty under Article 21, my lord.
What do you say, Mr.
Right, only it is so he has to file a show cause before the Madam Magistrate, Executive Magistrate.
Correct.
Because for that reason, section 482 invoking inherent jurisdiction.
It's only a show cause notice state, sir. That's what I told you earlier. You say.
Lordship, in the case may be permitted to withdraw or else.
Counsel petitioner seeks leave to withdraw with liberty to urge all the pleas available to the petitioner in accordance with law in response to the notice under section 110 CRPC. Disposed of is withdrawn, liberty is prayed for. The interim order is vacated. All right.
Your Lordship, here is a matter of without name in the FIR, my lord. Here the charge sheet has filed in the names. Only they are cultivating the carnival tree in the area, local area. That is my lord question. Nothing else, my lord. Petition name.
All right. Permitting the petitioner to urge all, please. Same order. All right.
22.
None appears dismissed.
24.
4. Correct.
24.
None appears dismissed.
25.
None appears dismissed.
26.
Same order.
27.
May I please, your lordship, on behalf of Mr. Bahadur. My lord, in this case, I am challenging the order of cognizance passed by the learned JMFC Jajpur Road. My lord, alleged offence are 407, 420 and 120B. My lord, in this present case, I am not in the FIR. I am not in the 161 statement. Only the offence allegation against me whether I have supplied the mobile and SIM card to the one of the co-accused. That on the basis of the conference.
Big things, sir. Mobile phones, these are.
My lord, I work as a salesman in the mobile shop. With proper documentation, I have supplied all the mobile and the SIM card.
All right. Permitting the petitioner to all the appropriate stage in the trial.
My lord, liberty may given.
Yes, same thing. That's what I wanted.
28.
None appears dismissed.
29.
None appears dismissed.
30.
Same order. Right.
31.
Lordship, item 31, may I seek an adjournment on behalf of Mr. Balram Naik? He's not attending the court due to some personal difficulty, Your Lordship.
All right. Counsel petitioner is in some personal difficulty. List before the roster bench. 12th January.
Your Lordship, interim orders may be.
Interim order to conduct.
Obliged.
32.
Item 32, my lord, I will raise my points to at the time of framing of charge, my lord.
All right. Permitting the petition. All right.
33.
That is, my lord, infructuous, my lord.
Infructuous dismissed. Interim order vacated.
34.
None appears dismissed.
35.
Lordship, on behalf of Mr. Manas Chand, for quashing up 1cc case on the ground that 243 CRPC petition was not allowed for during the trial, that the complainant has specifically stated that he had withdrawn certain amount of money from the bank account, and when the said bank account was asked for during the trial, didn't allow the same. The present petitioner has filed one petition on dated 1/8/2020 and prayed before the court to direct the complainant to produce the account statement of the complainant and her mother to verify whether the complainant had actually withdrawn 70,000 and rupees 80,000 from his account and his mother's account on the relevant, but the said petition was rejected by them. That's all.
Trial is still going on, sir, when you came here. There's no stay. Oh, there is a stay.
There is a state.
By now, the trial would have been over, but for the stay. You say permitting the petitioner to urge all please, trial court, the appropriate stage, the court declines to interfere with the impugned order of the impugned order dated 4th March 2016, passed by the learned SDJM Khurda in ICC case number 201 of 2012. The interim order is vacated. Copy of the order is sent. Right.
36. 36 may I please. In the source case mentions the present petition is the praying from to quas and seta said though in the say PS case number 117/113 pending in the law and SDGM Khurda Maluchi for the commission of alleged offense 420, 406 and 120B of IP.
Price chit, sir, chit fund.
The chit fund case. But the case has already been transferred to the CBI. But there is no necessity of annexure 1 which is registered in FIR in Khurda PS case number 172 of
That will automatically be taken care of, sir. But you don't have to interfere with all this.
As for the CBI also given the details on charge sheet has been which in annexed in page number 82 that investigation further transpired that no entity named in Artha Tattva was ever registered with the RBI and were permitted to collect deposit from the public. CBI also said that there is no such allegations against that present prisoner.
Anyway, you can seek discharge then.
I only information that no, if investigation is transferred to the CBI, that there is no allegations that FIR as no, there is no necessity of that FIR against the present prisoner.
It's all right.
I only pray from Quas and said that
permitting the petitioner to is all pleased with the appropriate stage in the trial. The petition is disposed of.
It will violate the section 300 of CRPC. That
whatever, sir, all that will be taken care of in the trial. All right.
Obliged.
37,
None appears dismissed.
38,
None appears dismissed.
39,
Your Lordship, the matter has been rendered infructuous.
All right. Dismissed as infractions. All right.
40,
None appears dismissed.
41,
So on behalf of Mr. Manastan, matter has become infructuous as 167 to
41. All right. Infractions dismissed. All right.
42,
None appears dismissed.
43,
Same order.
44,
May I please, my lord. But it may be granted for filing better application.
All right. Permitting the petitioner to resolve.
Same prayer for 45.
45,
Same order in 45. All right.
Public.
46,
46 ventilate all grievances before.
All right. Permitting the petitioner to raise all.
Sambalpur.
Please. All right. Same order in 47, 48, 46, 47, 48, same order. All right. 49 also. Sorry, 49, 50, 51, 52, 53, 54. This is a 55. All right.
In fact, matter is regarding my lord. I am challenging the entire proceeding.
Right.
Though the petitioner sold the all part of the property,
right,
but the third party claimed that once is filed a one case before the SDJM Sambalpur.
It's all right. So we permitted you to raise all, please. All right.
Yes.
Same order up to 55. Right.
56,
Pass the proceeding on the basis of matter the compromise between the parties, man.
but I am appearing for the informant, my lord. I am filing affidavit, my lord. The informant doesn't want to do this statement.
All right. An affidavit has been tendered of the informant. Opposite party number 2, stating that she has settled dispute with the petitioner and does not want to proceed with the complaint. Full stop. In that view of the matter, CT special case number 50 of 2017 pending the court of the Additional Sessions Judge Kamakya Nagar corresponding to Bhuvan PS case number 203 of 2017, and all proceedings and orders consequent thereto are hereby quashed.
57, 57,
None appears dismissed.
58,
Same order.
59,
Same order.
60,
It's all right. So none appears for the petitioner. Dismissed or non possible.
60,
That's why I am permitted to withdraw.
Dismissed is withdrawn.
61,
None appears dismissed.
62.
Please, my lord. My lord, here, my lord, the petitioner failed to quash the proceeding because in the trial, there was a common trial and also three of the similar footing accused as all acquitted, and the prosecution failed to establish the charges against the other accused persons. Only we see he is facing the split up trial. So instead of to save the precious time of the court, the result could have been the same.
There's no stay. Was a stay granted?
Stay is not required at all. Why should I also sought for a stay? Because I want the trial to be concluded in time. Because trial has already been. My lord, may I draw my lordship's attention?
No. So trial is already concluded.
Yes, trial because the present petition is also facing the split up trial. So she was
why did you say he's absconding?
Because
you have to say,
sir,
the present petitioner is absconding.
Absconding, but he was granted bail. He was on bail also.
Whatever. So you non-abscond yourself, you'll also get acquitted. That's an easy solution. All right.
Sir.
Permitting the petitioner to urge all pleas at the appropriate stage in the trial court. Petition is disposed of. All right.
63.
May I please, your lordship. My lord, the present petitioner filed this application challenging the cognizance order, my lord, under Annex C. Here is the case, my lord, the father-in-law filed a criminal defamation complaint as against the
daughter-in-law.
My lord. My lord, here is the only question will be decided before our lordships, whether the magistrate took cognizance but under section 468 or not. You also kindly see the ground number C, page 4 of my applications. I have stated the occurrence of offense 2/6/2012. The affair against the complainant and his family members. And the complainant and their family members acquitted in 2013, and the present complaint has been filed 2015 under Annexure 1. And the magistrate took cognizance 2016. My lord, my contention before our lordships, my lord, as per the 468 CRPC, my lord, the magistrate has no power to take cognizance beyond the period of limitation. That is my contention. Other side,
where's the other side? Who was appearing earlier? Akshay Kumar Samal.
Akshay Kumar Samal.
If it's barred by limitation, why should it continue, sir? All right. Although one Mr. Akshay Kumar Samal advocate had entered appearance on behalf of opposite party number 2, none appears today on his behalf. Paragraph. In the present application, the petitioner seeks the quashing of an order dated 2nd March 2016 passed by the SDJM Balangir in ICC case number 150 of 2015, taking cognizance against the petitioner for the offence under section 500 IPC. At the instance of the complaint filed by the respondent number 2, who happens to be the father-in-law of the petitioner. Paragraph. On the complaint of the present petitioner, GR case number 435/2012 was registered in the court of the SDJM Sundargarh against opposite party number 2 and 2 others for the offence under section 498 capital A/34 IPC, read with section 4 of the Dowry Prohibition Act. Stop. In the trial that ensued, opposite party number 2 and the other accused were acquitted by judgment dated 26th November 2018 passed by the JMFC Sundargarh. Full stop. Nearly 2 years thereafter, on 16th November 2015, opposite party number 2 filed a complaint, as a result of which ICC case number 150 of 2015 was registered against the present petitioner. Full stop. Counsel of the petitioner states that cognizance was taken by the SDJM Bolangir without noticing section 468 CRPC. Since the complaint related to an incident that occurred on 2nd June 2012. Full stop. Paragraph, although notice was issued in the present petition way back on 21st July 2016, no reply has been filed by any of the parties. Stop the averment of the petitioner that the offense itself, cognizance could not have been taken of the offense under section 500 IPC on account of the limitation prescribed under section 468 CRPC has remained uncontroverted. In the circumstances, the court quashes the aforementioned order dated 2nd March 2016, passed by the SDJM Bolangir in ICC case number 150 of 2015, as well as the said case itself. The petitions allowed no orders.
64.
Copy the orders and be sent to the concerned court forthwith.
May I please, your lordship? My lord, here the petitioner has sought for quashing of the criminal proceeding. That is a 1cc case. Complaint case has been filed by the opposite party number 2, who is none other than the nephew of the present petitioner. What has happened, my lord?
What is he? How is he related?
But he is the nephew of the
nephew. I see.
But what has happened? His mother filed a suit in the year 2006, seeking for transfer of the, seeking for partition of the properties, my lord.
So best is to have a settlement with your family members. Otherwise, there's no way of quashing this kind of a proceeding. Where is Mr. Samir Mishra was appearing? Why don't you people go for mediation, sir? Your civil suit is also pending.
Civil suit disposed of. Her share was given to her. She got it recorded in her name. Then he sold out the land. Thereafter, we filed an application for setting aside that compromise decree on the ground that fraud has been committed. That was brought before this honorable court. This honorable refunded the matter. That is pending before this honorable court, before the learned trial court. Now, my lord, when I
you want to keep your lawyers rich, that's what happens.
No, my
Civil proceeding, criminal proceeding, everything. Keep all fires burning.
I was just trying to take instruction.
Go for settlement, sir.
Yes, that is true.
Enough years have been spent on all this now.
Yes,
absolutely, madam.
So just tell your clients.
I am also in doubt whether my client is alive or not, because at least at the last 2 years I have not
tried to take instruction in the evening. We connected to my lawyer who is dealing with the civil.
All right. Both counsel inform the court that they will contact the respective clients to inquire whether they are prepared to go in for a settlement through mediation.
Yes, madam.
At their request list on before the roster bench on 18 January. All right.
Okay.
65. The interim order is there. That
interim order to cut. All right.
Item 34, my lord, that I could not appear. It has become infectious in the middle.
34.
I know, not yours maybe.
All right.
No. 65.
I am opposite but not to your lords.
All right. None appears to the petitioner. Dismissal on prosecution.
66.
My plea, the petitioner is challenging the order of taking cognizance. The same has been taken without sanction order, your lordship.
So all please.
Petitioner
Yeah.
My lord, the petitioner was a government servant, your lordship,
What is vacated?
and someone has been issued to him for appearance. I will appear, your lordship. My bail may kindly be considered, your lordship.
All right.
This is a summon, your lordship.
All right. Permitting the petitioner to urge all pleas if they are properties in the trial court. The petition is disposed of. It is informed that, when is it listed?
My lord, it was 1/10/2016.
Then that's over, sir.
My lord, thereafter, matter has been stayed by
Stayed
this
here.
honorable.
That's right.
Therefore,
So we permit you.
no subsequent order has been passed.
Correct, correct. So we are permitting you to urge all pleas. The interim order is vacated. Copy the order be sent to the concerned trial. All right.
My lord, I will surrender, your lordship. I was a government servant. In the meantime, I have.
No, on NBW, nothing here, sir.
My lord, someone has been issued to me.
That's right. That there's no stay of summons, is it? Is it? It's only stay of further proceedings.
My lord, but someone has been issued, your lordship. Kindly see the summon, your lordship.
That's okay. It's for a date. That's all gone, sir. And further proceedings have been stayed. Now you have to appear. That's it. All right.
Lord, on my appearing, my bill may be considered.
No, that's all not part of this 482. That you do separately. Yes.
67.
My lord, the petitioner is challenging the order dated, my lord, 6/12/2012 and 21/2017, annexure 5 and 6.
You're for the complainant. How? What? How? You're the accused.
Petitioner. And the land court, session court, my lord, has not taken into consideration the ingredient of Section 3 SC/ST Prevention Atrocity Act. The petitioner is a central government employee. While he was the accused, my lord, used unparliamentary words and threatening to the petitioner, my lord. But the petitioner belong to ST category, my lord, and the accused, my lord, threatened and used on parliamentary word, Adivasi Sola, illegal language.
Yeah. You don't have to use it here. Yes.
My lord.
Yes.
So, lordship, direct to laws 3 SC/ST PA Act against the accused man.
Yes.
This is my prayer in the petition, my lord, and I challenge the order of.
Let's read the order, sir.
Long trial court.
Let's read the order.
Yes.
Page 26.
Annexure 6, page 26, ma'am.
Yes.
Only 294 IPC taken into consideration against the accused.
See the actual words, if you come to page 29,
yes.
There's no reference to your being a member of the ST. That particular words.
There's not.
Just see the fourth line from the top.
Yes.
Unless I'm not. There is no reference, I think, to his being.
Public place, my lord.
No. What is the exact words? Just see that.
Adivasi.
No. That's not true, sir. Just see page 29, the exact words. Your name is Maji.
Abusing him by saying so and so, Sala Adivasi Maji.
No. The word Adivasi is not there. Just come to page 29.
Yes.
Fourth line from the top, the exact words.
Top, that the accused started abusing.
No. Where are you reading? Page 29, internal page 4.
Yes, my lord. I have.
The witness Kailash Chandra Patra and Arjun Mahanta.
Other page.
Just see the paperwork.
Say that. Oh, Master Singh. Oh, say it. Your lordship, may kindly see my affair, my lord. That is the.
No, what the court finds, sir. See, ultimately, the court is passing this order after witnesses have been examined. So what is the court saying that you have to see? Ultimately, what the witness in the box says is important. FIR may say so many things. No, it's okay. He's got.
Basing on my FIR.
FIR is not the last word, sir. FIR now is you have moved on. After FIR, there are witnesses now speaking.
And he has been examined under 200 CRPC laws. Initial statement has been recorded.
That's right.
My lord,
This is a section 200 complaint. Correct? Witnesses are being examined.
माझी साला तोते किए चाकरी देला
हाँ.
etc.
Ha. So where is that? What is that?
My lord,
Is that a reference to
this
being a member ST? No.
yes, member of the estimate.
No. I don't know. Is that right, Mr.
I have
Katkia?
Yes, Maji.
Oh, member Santala by subcast Santala.
No, I know, but his name is also Maji.
Maji also
Your Lordship, there is page 29, that first paragraph, last portion. There also, it has been very categorically relying upon the judgment of the Honorable Apex Court. The London Court has said is held that simply addressing a person by his caste without any intention to insult or intimidate doesn't constitute the offense under the said section. No, it is wrong, and they have preferred a revision after getting an order of revision dismissed. They have come up before the High Court. This is a second revision, which is not maintainable.
Oh.
For it to application, they have come up in a second.
So
revision.
earlier this was tested in the revision here.
Yes.
Oh.
Current.
Page 26.
Yes.
Oh, I see.
Against the revision order.
Wow, second revision.
Yes, against the revision order, I challenge this.
You can't again challenge.
Yes, not maintainable.
So it is a problem for you.
My lord,
Already a revision order in revision.
no. Against the session court, thereafter I can, this is maintainable, my lord. Against the session court, no higher further court. This court is appropriate court, my lord, Honorable High Court, to challenge that order.
No, against an order in revision, you can't file a 482, I think.
No, it is in the garb of
File, my lord, but the scope of interference is very.
Very limited. No, but factually, is there a reference to
yes, no, so in that way, that is in the top. They said slang language has been used saying Adivasi Maji. And Maji happens to be a schedule
Tribe. No, Maji direct subcaste. As per
no, but it's also his name, I think. It's also his name.
No, not name.
Yeah, his surname is Maji. Surname is Maji.
No, my lord. No doubt my surname is Maji, but Maji is subcaste in.
I know, if they're referring, calling him his name, that is, how does one know that?
Maji subcaste, central government notification are there. Maji.
No. There's no doubt that Maji belongs to a scheduled tribe.
Scheduled tribe.
But whether your surname is Maji, are they calling you by your name or referring as a to this being scheduled tribe? That's the difference.
Scheduled.
And even the witnesses who have been examined, one of the witnesses is nothing.
No, two of them said nothing like this was said, but two have them.
6 witnesses, who postmaster in favor of the petitioner, and 3 independent persons, they have stated nothing.
No, that's okay, but numbers don't matter, sir.
No, that is the evidence of the tribe. Out of 6 witnesses, 3 independent stated nothing.
While he was on duty, all of a sudden, such type of used unparliamentary words, and you come to outside, I will see you.
No, we are now on the SC/ST Act, sir. So what's the threshold for that? Other offences he's going to face trial anyway. You're on the limited question of SC/ST Act. So for that we have to test. Anyway, the case is going on under the other offences.
This is enough, Mala. Maji sola tote kiye chakri dela, and ita
so and so, Sala, Adivasi, Majhi, etc.
That part I'm not able to get. See, page 29, the words used as far as the witnesses can say these things. Just come to page 29.
14.
What you say in the FIR is one thing. These are not the words used by the witness. That's the difference. That's why the judge is saying this does not amount to an insult. Come to page 29.
Yes, madam.
Because you are all the time reading your FIR. That's the problem.
FIR, my lord. Madam, page 12, my allegation FIR. Adivasi Majhi. What says in the FIR, my lord? That is recorded in the order of law court, trial court.
All right. You say the challenge in the present petition is to an order dated January 2017 passed by the Additional Session Judge Karanjia in Criminal Division number 11 of 2013, declining to interfere with an order dated 6th December 2012 passed by the SDJM Karanjia in not taking cognizance against the respondent accused, the opposite party accused, for the offence under section 3(1)(10), small Roman 10 of the SC and ST POA Act 1989. Full stop. As noticed by the learned ASJ, under section 3(1)(Roman small 10 of the POA Act, who are not being member of a scheduled caste or a scheduled tribe (ST) intentionally insults or intimidates with the intent to humiliate a member of the SC or ST in any place within the public view is liable to be punished. Paragraph. The relevant portion of the impugned order in this regard reads as under. Take from bottom of page 28. It is alleged by the complainant up to under the sixth section in page 29, unquote. While counsel to the petitioner kept reading the relevant line from the FIR, it is plain that what two of the witnesses stated was slightly different and has been extracted by the learned ASJ in the above paragraph. It does appear that the conclusion of the ASJ that there is nothing in the said statement which could be said to be with an intention to insult or intimidate the complainant for being a member of the ST is correct. Stop. The view taken by the ASG appears to be a plausible one. Paragraph, consequently, the court is not persevered to interfere. The petition is dismissed. Right.
68.
May I please?
Yes, please.
After closure of the argument in a sessions trial, a petition was filed under section 311 to examine 5 witnesses, those who are not named in the charge sheet and were not even the witnesses who were examined, 11 witnesses were examined on behalf of the prosecution. None of them have stated that these witnesses are the material witnesses and they were present at the time of occurrence. And the evidence was closed.
What's the offense, sir?
That the offenses is 307. The major offense is 307. And 147, 148, 294, 307, 506.
So obviously they're being tendered as eyewitnesses.
Like they have not been tendered as eyewitness.
No, now.
Now they have tendered.
Huh.
If there is no explanation, my lord, I am not disputing the position of law that at any stage of the
Anyway,
proceeding.
cross-examine them, sir.
Your lordship kindly see this for a moment of the judgment of this Supreme Court. Only one paragraph. This case is coming under that exception. Your lordship kindly see paragraph 12.
Give me the date long back.
Long back, your lordship can see. 29/7/2010 evidence started.
All right.
On behalf of the prosecution. And it was closed on 22/12/2016. But for long 6 years.
No, the trial went on. It was closed on 22/12/2016.
22/12/2016.
But when is his application filed?
But the application was filed on 13/6/2017.
6 months.
13/6/2017.
Sir. So it was closed only 6 months.
And you also can see the Supreme Court, what the Supreme Court has observed.
That's right. Para 12.
Para 12. Para 12. Where the prosecution evidence has been closed long back.
Long back means when?
And the reason for non-examination of witnesses.
Here, long back is 6 months, sir.
Not satisfactory. And here is also an identical decision of this honorable court.
Sir, just 1 minute.
Yes.
So there the delay was 2 years. After closure in 2011,
yes, ma'am.
The application for summoning was allowed in 2014.
That's right.
But
here there is no explanation.
Here it's
there is no explanation. And it should be explained by the witnesses, or there should be stated slightest indication in their evidence that these are the material witnesses who have not been charge sheeted, or that they have not been called for examination. There is no indication in the entire evidence from the side of the prosecution before closure. And this court has also considered that circumstances in another case, 2011 supplementary to OLR 410. Here nothing has been stated in the petition also, your lordship can see.
So one is a medical officer. There are 2 medical officers here.
2 medical officers. I have no objection, my lord. So far other 3 witnesses are concerned, my lord. Even there is evidence, I'm conceding to that effect, my lord. But to that extent that there is some evidence that they have been examined at the SCB Medical College. So therefore, so far as the doctors are concerned, my lord, your lordship may allow. But so far as the other 3 witnesses are concerned, there is absolute no foundation, my lord. So, absolute no foundation.
It's all right. For 5 years, it's all stayed. Whatever they remembered, they must have forgotten by now. Those witnesses. Your purpose is served.
That is there, but your lordship can't.
That was the whole idea. That was the whole idea. You came here, got it stayed for 5 years. Now there's nothing left. You see, counsel for the petitioner.
But the consistent view is that they should give certain indication in their evidence.
All right.
If there is no foundation at all, then
you want me to
witnesses cannot be.
You want me to deal with all this, or all right?
Yes.
Counsel the petitioner relies on the judgment of the Supreme Court in Swapan Kumar Chatterjee versus CBI 2019-14 SEC 328, where it was observed that where the prosecution evidence has been closed long back, and the reasons for non-examination of the witness earlier are not satisfactory. The summoning of the witness at belated stage would cause great prejudice to the accused and should not be allowed. Full stop, unquote. However, in the present case, it is seen that while the prosecution evidence was closed in December 2016, the application for summoning 5 more witnesses, 3 of whom was stated to be eyewitnesses, and 2 medical officers, was filed in June 2017, that is within 6 months. It cannot therefore be said that the attempt at summoning more witnesses was single quotes belated or long after the closure of the prosecution evidence. Paragraph as rightly observed by the trial court, the petitioner would not be prejudiced severely, greatly prejudiced, because in any event, the petitioner would be able to cross-examine the said witnesses. In that view of the matter, the impugned order does not call for interference. The petition is dismissed and the interim order is vacated. The copy of the order be sent to the concerned trial court.
69.
69 permitted to
dismiss is withdrawn. Interim order vacated.
70.
May I please your lordship? The maintenance amount under 125 CRPC.
What is it?
My lord, by the STGM code, then a STGM granted 5,000 towards monthly maintenance.
5,000.
5,000.
What are you working as?
He's an employee under railway, my lord.
Sorry?
Husband. I'm for the husband.
No, what is he doing now?
He's an employee under the railway.
Railways.
Railways. And no, the issue here is, my lord. After the wife again filed a petition under 127 CRPC for enhancement. Enhancement, the learned court announced to 3,000 further, making the maintenance amount into
8,000.
8,000.
She's not working anywhere.
From the data portal.
That's all right.
Then thereafter, my lord, just to one submission. The matter was carried in revision before the Sessions Court. A Sessions Court upheld that order. My only grievance before your lordship is that the ground on which the announcement was sought, my lord, paying the house rent and some medicine, no material were produced before the court.
All these are not matters to interfere, sir.
And another submission, my lord.
Yeah.
This honorable court, by order dated, your lordship may kindly see order number 651/2018.
Reduce the enhancement to 1,500.
1,500.
What is this?
So
why should we? What can a person live on 8,000 a month, sir? Just imagine. Where is she staying? Bhubaneswar.
No, at Raigada.
Wherever, even Raigada. These days, the cost of living so much. What can a woman survive, sir? On 8,000, nothing. She can't even survive.
So what
the enhancement amount being just 3,000 per month, and with the petitioner being an employee of the railways, the court does not consider the impugned order of the trial court to be warranting interference. Full stop. Given the inflation and the cost of living, general cost of living in cities these days, even in the city of Raigada, expecting a woman to survive just on a sum of rupees 8,000 per month is being unreasonable. Full stop. If the petitioner, the court is therefore not able to countenance the plea of the petitioner, the above sum awarded by the trial court as maintenance, as interim maintenance to the respondent wife is excessive. Consequently,
maintenance.
as maintenance is excessive. Consequently, while declining to interfere with the impugned order, the court dismisses the present petition and vacates the interim order. A copy of this order be sent. You say, as a result of vacation of the interim order, the arrears of maintenance payable by the petitioner should be paid to the respondent wife within a period of 8 weeks from today.
71.
I may permitted to withdraw.
Dismisses withdrawn. Interim order is vacated.
72.
May I please, Your Lordship? The petitioner challenging the proceeding of the case, Your Lordship, on section 498 and 494 of Indian Penal Code, as per annexure 1, Your Lordship. But it is peculiarly, it is detailed in annexure number 2 series that the informant has married to another person before lodging the affair. And in that affair, she has lost against affair in 11/9/2015. 498A and other offenses, your lordship. As that time, she has a 11 years child. But as per the allegation of the present informant, when the marriage was solemnized, I was 17 years old. So the false case has been lodged against me because, and as per the allegation in Annexure 1, that there was a love affairs and I has before this temple. But before my marriage,
So all this can't be gone into this stage, sir, these proceedings. Let's go for trial. Permitting the petitioner to raise all pleas with the appropriate state of trial. The petition is disposed of, the interim order is vacated. All right.
73,
And appeal is dismissed.
74,
Petitioner filed this case for quashing the proceeding on the basis of my lord. Petitioner is the husband, my lord, and
498A.
384 FIR lodged under section 384 IPC, but charge sheet submitted for the offense under section 384, 366, 354C, 506 of IPC, my lord. Well, Annexure 4 is a marriage certificate, my lord. Thereafter,
where is she now?
My marriage certificate, page 19, my lord. Thereafter, section 9 of the Hindu Marriage Act, filed on 17/8/2016, after getting notice, my lord, the petitioner lodged the FIR. Sorry, OP number 2 lodged the FIR against the
OP number 1 or lodge the FIR, sir?
my lord, sorry, my lord. Against the petitioner, my lord.
Anyway, sir, we permit you to raise all pleas. Permitting the petitioner to raise all pleas at the appropriate stage.
I am appealing for the opposite part number 1. My information is now they both are living separately.
That's what. So permitting the petitioner to raise all pleas at the appropriate stage, the court declines to interfere. Same thing. Interim order is vacated. Right.
76,
I can raise all the points.
All right. Permitting the petitioner to raise. All right.
77,
No instructions dismissed.
78,
The petitioner prays to question the entire proceeding because before the landed court below, both the parties submitted their compromise petition that their matter has been settled between them, and after considering the aforesaid compromise petition, landed court below released the accused persons on bail. Kindly see page 30.
No, but for the purpose of the present petition, where is that? There's no affidavit by the complainant. As far as this petition is concerned, there's no such affidavit of the complainant.
Before the landed court below, they filed the compromise petition. Can you see?
No, that may be. That's for the purpose of bail.
Yes, sir.
And
they do not. Can you see page 30? Kind of page 30, dated 2nd March 2015. The case record is put up today. Landed counsel for the accused person Sukanta Behra and others are present, and landed counsel also filed a compromise petition and submitted that the matter has been compromised between them, between informant and accused person, and they did not want to progress in this case.
No, that is just recording that there is a compromise petition.
After that, on perusal of case record, it is found that the accused persons were forwarded.
So it is only for the purpose of bail, correct?
Yes, sir.
That is at one stage. For the present purpose, this petition, there's no such similar petition or affidavit of the respondent to.
Informant not been made a party.
No, made a party.
Yes, sir.
By hand, it's been added. Yes.
Till that,
he's not come forward to.
Yes, sir.
So he's not come forward to file an affidavit here.
Can you next week, next week can you take a note? I will file this.
All right. At the request of the counsel for the petitioner, who states that an affidavit will be produced of opposite party number 2 regarding the compromise of the dispute between him and the present petitioner, list before the roster bench on 9th January.
Oh, blessed.
Interim auditor cut. All right.
published.
79.
May it please your lordship, I am appearing on behalf of Mr. Chinmay Mohanty, counsel for the petitioner. I may be permitted to raise all.
Raising, yeah, permitting the petitioner to resolve, please. The property.
Published, lordship.
All right.
80.
My lord, this is the application for quashing of the criminal proceeding, my lord, of offense under section 498A for DP Act, my lord, offense made out. 5 accused is there, my lord. Out of 5 accused, 2 accused has been expired, my lord. And on dated 3/6/2006, cognizance of offense taken, my lord. Thereafter, the bail application has been filed by the present petitioner and
Madam, unless there is a compromise or an affidavit filed by the complainant, we're not going to quash these things.
my lord, now 22 years, my lord. There is nothing, my lord. Your lordship may see annexure 1, my lord.
Then we can't go into in a 482. So the point is, these are matters for trial.
My lord, your lordship may see 3/6/2006, the present petitioner has filed one memo that the accused number 3 is expired since 5 years back.
That's okay.
Thereafter, your lordship may see all the dead, my lord, they have taken for death report not yet received, put up on 1486 for report. Thereafter, 1486 fixing 1/2/2007 for report, 1/2/7 for 2597. My lord, 22 years I have suffered, my lord. Your lordship may see there is I have put 3 decisions, my lord. Article 21, my lord. One petitioner is a defend of, my lord, and a third one is a married, my lord. I'm suffered since 22 years, my lord. Lordship may see the decision, my lord. Violation of Article 21, my lord.
No. Was there any stay granted?
No, my lord. Matter is sub judice. I have filed one application 227 after filing of this application. My lord. That application is also heard, but no order has been passed as
All
of
right.
yet,
The
my lord.
grievance of the petitioners is that no progress is being made in GR case 299 of 2001 in the file of the learned SDJM Jagat Singhpur. A report is called for from the district judge, Jagat Singhpur, as to the actual progress of the case from its inception.
Your lordship may see order dated 81/18.
Let the report come.
My 81/18 also your
We
lordship.
are giving a date, madam. Let the report come from the district judge.
Your lordship.
It's before the roster bench. January 10th. Right.
81.
Lordship may kindly have glanced to page 18 of my brief, in where the petition number 6, my lord. There are 10 petitioners before your lordships. Out of 10, 7 of the ladies persons, and out of the 10 petitioners, petitioner number 6 is the informant. Because of her daughter has been brutally murdered by her in-laws, my lord. Accordingly, one FIR law 498, 300 February, 302, and also pending. At that time, since the police was not arrested, the accused persons, and moreover, my lord, during the substance of the case before the police, my lord, the accused persons are threatened in dire consequence, my lord.
You're for the complainant.
I'm for the complainant.
How did it help you to get the proceeding stayed?
No, my lord.
Why did you get it stayed?
Because of her, not that, my lord. Because of, in that case, while I along with my other ladies persons went to the police stations, since the accused persons are threatening me in dire consequence, and with FIR before the police, my lord, police did not accept my FIR, and accordingly, the annexure 1 has been filed against me.
So you're the accused.
No,
you're not
my
the
lord.
complainant, sir.
No, my lord. I am the complainant as against my.
That's right. That's some other case.
My lord.
As far as this case is concerned, you're the accused.
Accused.
When I asked you, are you complainant accused? You wrongly said you're the complainant.
No, look,
in this case, in which you have come to this court, you're the accused.
No, my lord. In the
In the present case which you have come before, you are the accused.
Yes, my lord. That is unanswered one.
So don't mislead the court, sir. When I specifically asked you, are the accused, you say no, you're the
Yes, my
complainant.
lord. But which that is I am accused in unanswered one, my lord.
Whatever, that is what you have come here for.
Yes, my lord. That is unanswered one. Major offense, my lord, 354 and 353 and 506.
All right, we permit you to take all pleas, sir. Permitting the petitioner to take all the pleas available to petitioner in accordance with law before the trial court. The petition is disposed of.
My lord,
Interim order is vacated.
my lord, for a moment, my lord. I will give me liberty, my lord, press the same at the time of framing of charge.
That's what we've said all that.
Framing of charge, my lord.
Yes, yes.
Oblige, man.
82 and 83, my lords, I'm for the petitioners. But in 82, I've received the instructions that the petition number 1 and 2, they have died in the meanwhile. And my lords, so far 83 is concerned. Now this involves a demarcation case which was carried out by the sub-collector and the Amin. And the sole contention is, my lords, that the prosecution sanction was not taken. While the demarcation.
Take all the pleas, sir. You can always file a discharge for that.
I'll file.
Both petitions, you say permitting the petitioners to seek. You say petitioners 1 and 2 in 81, you say petitioners 1 and 2 are stated to have expired. The criminal case against them would obviously await. As far as petition number 3 is concerned, permitted to raise all pleas at the appropriate decision of the trial court. In 82, same order. That is permitting the petitioners to raise all pleas. The interim order is vacated.
I am appearing for OP2.
All right. All right.
Obliged.
83.
82 and 83, my lords. In 82, the petition number 1 and 2.
Correct.
Obliged.
84,
None appears dismissed.
85,
This the initiation proceeding and the order of taking cognizance. Annex 5 that is under challenge for lordship. Fact remains that the petitioners are the engineers and staff of the distribution licensee. They visited to the village of Badam Pass for inspection of the inspection under section 126 of Illicit Act 2003. And annexure 1, you look, lordship kindly glance at page 20. During verification, we found that the one Brahmananda Biswal in his house, one TV cable TV transmitting unit is running. And accordingly, that assessment proceeding was initiated.
Who's for the respondent number 2?
That PK Das name is there. Is PK
All right. Since now nobody is appearing, you say one Mr. PK Das was earlier appearing for officer party number 2. However, today none is appearing on his behalf. In the interest of justice, let's move to the roster bench. On 7th February, interim order to continue.
Obligations.
86,
Your lordship, case under section 211 DB Act lordship. Your lordship, under section 29 DB Act appeal provision is there, but may be given to
All
raise
right.
all
Council
these things.
petitioner seeks leave to withdraw the present petition with liberty to avail the statutory remedy of an appeal in accordance with law against the impugned order.
Lordship, delay may be.
The appeal is filed not later than 1st February 2023, accompanied by an application continuation of delay, explaining the delay on account of the pendency of the present petition. It shall be considered in accordance with law by the concerned court. The court clarifies it has not expressed any view. The petition is disposed of as withdrawn, liberty is prayed for in the above terms. The interim order is vacated.
87,
May I please, your lordship, on behalf of Mr. Manas Jan. Lordship, the petitioner is a jewelry shop owner. During the course of investigation, several new gold ornaments and silver ornaments were seized from his shop. On the plea that a co-accused person has stated that he has co-accused person who is a chain snatcher has stated that he has sold the chain to the present petitioner. Thereafter, he moved a 457 petition before the learned trial court. The learned trial court did not allow the same. Then he moved for a revision. During the revision, the learned session judge, first session judge only released his cash, but he was having the
There is no stay of the trial, sir. By now it must be over. Till now, there is no interim order here. By now, the trial must be over. With there being no interim order passed with this court at any stage, it is most likely that the question is already concluded. But in any event, the petition will be permitted if the trial is still pending to urge all pleas at the appropriate stage in the trial court. The petition is disposed of. Next.
88,
May I please, my lord? My lord, in this case, my lord, the challenge is the order of cognizance under section 113 of the NI Act. My lord, the present petitioner is the mother of the accused, the second accused, my lord, in whose name the property was purchased. But so far as the drawer of the check is concerned, it is the accused number 2. My lord, your lordships are squarely covered by the judgment of the Honorable Apex Court, where my lords have held that it is only draw the check.
Where's
who can
Mr.
help-
Abhilash Mishra? He's the complainant, right? Mr. Abhilash Mishra is appearing with the complainant.
Yes, my lord.
Although Mr. Abhilash Mishra, advocate, was appearing for complainant opposite party number 2, today none appears. In the interest of justice, list on 8th February, interim order to continue. Grateful. There is an interim order, correct?
Yes, my lord.
89,
May I please your lordship on behalf of Mr. Bijay Kumar Agda, kindly raise all the point code below.
All right. Permitting the petitioner to raise all, please. Right.
90,
90 permitted to withdraw, my lord.
Dismisses withdraw. All right.
Problem.
Interim order is okay. Special bench is at 1 o'clock.
I have been in custody since the
No,
conviction.
but you don't appear when the matter is called out, when the main appeal is listed.
Yes, yes.
None appeared and we had to appoint an amicus curiae. And now I think the trial has been, the appeal has been expedited.
Yeah.
In the co-accused's case.
Appellate
391,
yes,
I think the date has been fixed.
Yes, boss. Yes, boss. Third week of January 2023.
Yes, let the appeals be heard now.
Yes.
None appears when the appeal is listed. In your case, 465, none appeared.
My lord, recently the power was given to me to appear in this case.
No.
And I filed the wakalatnama.
No. You're the legal aid. Who was the legal aid counsel here? We had appointed a legal aid counsel. Just see our order. Have you seen our order dated 6/9/2022? You've not seen that order. You have to inspect the file, find out what orders are passed in your case. Unless you do that, how will you know what is happening?
My lord,
You have to first do that. When somebody is entrusting it to you, you have to find out what has happened in the case. You say it is seen that the appeal of the co-accused, that is criminal appeal 391 of 2014, is already listed for final hearing in the third week of January 2023. The present appeal will obviously be heard with the said appeal. In that view of the matter, no order is passed in this application at this stage. It will be for the roster bench which considers the appeal. No, at this stage, the present appeal will also be heard with the said appeal on the same date. All right. The petition is adjourned, right? The application is adjourned. All right. Right.
Sir, no.
Yes, namaskar.
Sir. Sorry, sir. Sorry, sir.
No, please.
May I please, your lordship? Yes. It's an application for review of lordship of order dated 2010-2020, passed in WPC number 6413-2004. Your lordship has effectively allowed my application, but the only fact is, your lordship, the petitioner was a protected workman. Under section 33 of the Industrial Disputes Act, your lordship. Can your lordship read section 33, your lordship? 33(3). Protected workman.
No, what is your grievance?
Yes, your lordship. There is no grievance. It's a written judgment. I am bowed down to your lordship. But the fact remains, your lordship, only portion with regard to the pensionary benefits are not been reflected if the petitioner is entitled. Now the corporation, they're not paying him pension after his retirement.
Yeah, because this was in lieu of reinstatement.
Yes, sir.
5 lakhs compensation lieu of reinstatement. Once it's in lieu of reinstatement, where's the question of pension?
Yes, your lordship, because 15 years I was out of service. And your lordship has already...
Maybe that's a separate cause of action then.
Exactly.
You can't combine it with this now. There's no review of this. There's not a ground for review of this judgment.
Because your lordship, I have already retired. Your lordship has already held that in the
That's
judgment.
right. You already superannuated. So that's a separate cause of action, not grant of pension.
Now, your lordship, this petition is 62, 63 years of age.
That's all right. That's all right.
If your lordship can observe that the petitioner will be entitled for...
No, you withdraw this with liberty to pursue other remedies for your pension.
And at the time of attaining superannuation, age of superannuation, you are under suspension.
Yes, your lordship.
And the court has explained and given reason at para 15 why a lump sum amount has been awarded.
Yes, your lordship. I'm not against that, your lordship. That's absolutely correct. I bow down. My only contention is because he has superannuated and only one submission, your lordship, for my satisfaction. Only one submission for my satisfaction. when your lordship, the dismissal is bad in law, your lordship cannot reinstate me because I've retired, but at least I'm entitled for the
That's a
constitutional
separate,
benefit.
that's to be urged separately, sir.
Because
Separate
my lordship,
proceedings.
my prayer in the application was very specific. My lordship, kindly see my prayer in the writ application. My prayer was for reinstatement as well as the constitutional service benefit. Now in the meantime, you have retired, your lordship. At least I'm entitled for the pensionary benefits. That has to be construed in that line.
Not really, sir. That's a separate cause of action. You say no ground is made out for review. The review petition is dismissed. All right.
My lordship gives the liberty to.
Then you withdraw. If you want a liberty, you have to withdraw the review petition.
I will withdraw, your lordship.
All right. Constitutional petitioner seeks leave to withdraw this review petition with liberty to seek other appropriate remedies as may be available to the petition in accordance with law as regards his retirement benefits.
My lordship.
This post is withdrawn with liberty straightforward.
I'm grateful, your lordship.
I don't know to
For clarification about.
Like K.
Yes. For recall and slash clarification of order 3/1/2020, because that is the noting.
None appears. You see.
None appears.
IA number 794 and 367 of 2020. None appears for the applicants. These applications are dismissed. All right. Right.
Namaskar.
Namaskar, sir.
I don't know one.
Your lordship may kindly accept my requisites. I bow down to your lordship. It is filed late. My old clerk could not file. Requisites may be accepted. I have filed it.
You have filed it?
Yeah, again.
Okay.
Notice may go.
Counsel for the petitioner states that requisites have now been filed. Notice be issued now on that basis, returnable on 27 January.
Yes, this is my receipt, man.
That's all. We keep it.
Obliged.
Okay, sir.
His name was on record, so couldn't appear on that day.
What's the main matter about?
Main matter, my lords, we are challenging the order of the OEA authorities. Valuable land rights are involved. I have given a short note. So on merits, we have a good case.
All right. No, we'll first have to allow this and then restore it. You say for the reasons stated therein, the application is allowed. The order dated 12th April 2022 is recalled. Writ petition civil 104 of 2011 along with the interim order is restored. Then the main writ petition, this has today been restored by virtue of the order passed in CMAPL. Then you say list before the roster bench on 9th February. Interim order to continue.
We are all ready.
I don't know for.
Yes, please. My lord, please allow me the 2 weeks time to remove the defects and praying for the continuation of delay of 9 days filing this appeal. This CM.
All right, that IA 163 delays condoned. What are these defects?
I have to check it. Today on I came to know this listing is some defect is there. Maybe the pagination or some others are there.
Actually, there were defects in the original writ appeal itself. That writ appeal defects you have not removed.
Allow me 2 times. I'll remove. That is already been disposed of. I'll check it. The previous council was.
Okay, you said defects be removed within a week. List on 23rd December. All right.
Obliged.
All right.
Namaste, my lord.
Namaste.
Namaskar. I don't know one.
Not if this application, in fact, the age was disposed of in absence because the name could not appear in the list. I have annexed the list. My appearance also could not be noted. Thereafter, I filed an application for review. Ultimately, it has been converted by your lordship's order written. 4/11/2000.
No, so what is his objection to the IA now?
I am my learner is filing now.
Yeah, filed the objection. The questions that arise in legislation, my lord, is that inherent power, the 151, whether can be invoked when an ex parte judgment is passed. My lord, this honorable court in the full bench 1980 has held that when a specific provision is there, it cannot be done. Now, my lord, the other aspect is that whether power under the latest patent appeal is appealed to the restriction under section 100 of the CPC. The Supreme Court answers no, it is not. So it is on fact and law, both. So, my lord, your lordships, while dealing with the latest patent appeal, has given a categorical finding that a God shouldn't property. Now, a God shouldn't property exists in the plane. It is not that the God shouldn't is not there in the plane at all. I mean, the third objection is.
No, the main point is he was not heard. That's only the main point.
Then let it be heard. There is no difficulty.
Huh.
But why recall that order?
Meaning? How can the order remain and he'll be heard? He'll be heard where? In which matter?
Mr. Pal, don't be so over technical. He was not had. He filed his
Justice Bhavta, it's my duty.
That's true. All right. A written note of submissions has been filed by Mr. Pal, raising certain objections to the entertaining of the present application by the court. Full stop. However, he is unable to dispute the fact that counsel for the applicant, that is the opposite party number, or is it respondent?
Respondent.
Respondent number 1 in the AHO 34 of 1998 was in fact not present and therefore not heard when this court passed the order dated 5th November 2021. Correct. Given the nature of the case and the fact that the order has adverse consequences for the applicant public respondent, the plea that it ought to have been passed after hearing the respondent number 1 appears to be well founded. Full stop. For the above reason, the IA is allowed. The order dated 5th November 2021 is recalled. And AHO number 34 of 1998 is restored to file along with the interim orders that were present. Is it? There was an interim order? No. Restored to file. In the main AHO 34 of 1998, the present appeal has been restored as a result of the order passed today in IA number 2 of 2022. List before the roster bench on 30th January 2022. All right.
And to point out the
laying of pipeline application has been filed. In course of hearing, this noble court please to direct production of videos to appreciate the position of the laying of pipeline and other aspects. And consideration of the same, your lordship are pleased to direct my friend to find out whether it can be dead in the alternative route or not. As it appears, the affidavit that has been filed, they don't agree to that, saying that it will have to cost effect and other things. But what now I humbly beg to point out to your lordship is that on the face of it, whether the review is warranted or not, and whether there has been inherent defect in the very acquisition itself. Because this, your lordship's order directing them that whether the alternative would be is possible or not, was there pleaded by us before them right from the inception when there was no pipeline at all. What I humbly beg to submit, had there been adherence to the provisions of the act which they are governed by for laying pipeline, possibly this occasion would not have arisen by now. So the section 3, which matter before placing the factual position little bit to your lordship matter for appreciating as to whether I am correct vis-a-vis the position of law or not. I want to point out one thing. These writ petitions were, set of writ petitions were filed. Filed an affidavit saying that we will adhere to the safety measures. So apparently your lordship has been pleased to find out from the record. It is in fact not feasible because that kind of space is not there to lay a pipeline, which is a high pressure pipeline. It's not those pipelines where the connections are given to the homes. It's a high pressure pipeline from where again the connections will be given to the local people.
Correct.
So therefore, so far as section 3 is concerned, with your lordship kind permission.
Mr. Mishra, before you proceed further, Mr. Mishra, can you hear me? Before you proceed further, I have a suggestion. Subject to my lord's approval, since before the project is made operational, they are going to conduct a safety audit. Why don't you appear before the safety auditors? Raise these points. We'll keep this matter pending. Let them give a finding. Whatever objection you are raising, raise it before the safety auditors. Let them go through it. We'll keep the matter pending. Before it is made operational, let them give their opinion. Because technically they are the experts.
Because ultimately your concern is about safety of the residents.
Right.
One thing I want to humbly point out to my lord is that if they give a safety opinion in an independent body, I have no grievance. Your lordship direct that. Your lordship direct them not to at least my lord pass on.
Before the project is made operational, that's what I'm saying. Qualified. Before the project is made operational, they will give their opinion.
Before without leave of your lordship, let them not make it operational. That much I am praying.
Yeah, that's all. We'll keep it pending. Let the safety audit happen.
Well, because what has happened, your lordship will kindly consider there is not even notice except to individual owners, your lordship.
But now you have all that notice, all that is over. That stage is crossed. Now we are on the safety part.
Safety part.
Safety part of it, and your lordship will see it is not feasible, and let them give an opportunity of hearing.
No, once you appear before the safety audit, they will obviously hear you.
My lord, your lordship keep it pending. Only I am praying. Like
Who conducts the safety audit? You tell us who conducts the safety audits.
My lord, as far as my instructions are concerned, first it is an internal audit, then external agency is there. Then I believe it is all approved by the PNGRB or the authorities under the Petroleum and Explosives Act.
Okay.
Because this cannot be charged with gas unless this has crossed those certifications. So what my friend says, that is fine because we are not going to make it operational anyways
without the certificates.
Yes, my lord.
All right. Under which provision is this audit happening?
My audit, in fact, I may be pardoned so far as the audit part of it, I think it's a circular. So far as the notice part of it is under section 7.
No, that's right. But the audit, we are not on the audit part.
My lord, I believe it would be under the regulations that have been relied upon by the petitioners.
And also section 7
Or-
provides with regard to the safety measures.
Or my lords,
yes,
feel then I may place on record the details of the proposed audit so that a specific order can be passed.
One thing, we may be hard because we'll just point out.
That's right. Let him first tell us which is the agency, when it is going to conduct the audit, and then we'll pass appropriate orders. An affidavit be filed by GAIL informing the court the schedule in terms of which the time schedule for the conduct of the safety audit of pipe question and the name of the agency which will conduct it to enable the court to pass further directions in the matter. The affidavit be filed positively 1 week prior to the next date with an advance copy to counsel for the review petitioners. List on full stop. You say counsel for GAIL informs the court that till the safety audit is completed and a certificate is issued, the pipeline in question will not be made operational. Full stop. Then you say list on 3rd February.
My lord, may I please request for an earlier date?
No problem. If you can
January,
file it, it's not a
maybe
problem. 20th January?
Second week of
20th January. All right.
Grateful, ma'am.
All right.
I beg pardon.